Constitution, the Second Amendment, was never absolute. You couldn't buy a cannon when the Second Amendment was passed. You couldn't go out and purchase a lot of weaponry.
All right, well, President Biden's claims about the Second Amendment and cannon ownership have many fact checkers in a tizzy today. Here to set the record straight on what the Constitution really says about gun ownership, Harvard Law School Professor Emeritus, Newsmax analyst, and the host of The Dersh Show, Professor Alan Dershowitz. Professor, I'm going to take your understanding of the Constitution with respect to the Second Amendment over the president right now, because I think a little of his rhetoric is misguided. So explain to me, I'm not really that concerned about cannon ownership. I gave up on cannons a while ago. Walk me through what the court has said with respect to the Second Amendment right now.
Well, the Second Amendment has one thing that everybody agrees about. It's badly drafted and it's unclear. It could have just said the right of the people to own guns or to bear arms shall not be abridged. That would have been simple. Or it could have said, because we need militias, the right of the people to own guns so that they can use them in the militias should not be abridged. But they didn't say either of those things. Instead, they had this hodgepodge of words saying, you know, the need for a militia for to preserve a safe democracy. Therefore, essentially, the right to bear arms shall not be abridged. So advocates on one side say the Second Amendment only provides really for guns that are necessary for states to have a militia. And advocates on the other side say, no, it provides for the right to personally own guns. And for 150 years, one interpretation prevailed. And then over the last generation or so, the Supreme Court and other courts have said that the right to bear arms shall not be infringed, gives citizens the right to own guns. But they have also said that some restrictions are possible. After all, the amendment says a well-regulated militia, and therefore some people have interpreted that to mean that the states have the right to well-regulate guns. And that dispute will go on, and it's before the court now in a New York case involving Rensselaer County and whether or not you can own guns without providing a justification for it. So it's very much up in the air, and the right to bear arms aspect of it has prevailed in the Supreme Court up to now.
So I do want to ask you about that case that the Supreme Court is expected to rule on any day now. It's the first time they've actually heard a case on the Second Amendment or ruled on it in almost over a decade. So right. We know that this is about hand-carrying concealed weapons. That's what this New York law is on the Supreme Court is hearing. But yesterday on our show, we had Florida Congressman Mike Waltz on talking about reforms and states' laws. Listen to this.
At the end of the day, this should be something for the states to handle. I'm not going to get on board with a federal one-size-fits-all law on this, as though it's some kind of magical solution. And I think it's different in, say, Montana or Wyoming than it is in downtown LA. And that's why state legislatures have a role. And state legislatures ought to do, ought to focus on what's appropriate for their communities.
He's 100% right. State legislatures, but cities as well. I mean, Los Angeles is very different than rural California. Now, California passed a statute recently in which they prohibited people from the age of 18 to 21 to own semi-automatic weapons. And a court there struck that down, saying, no, the state had no right to prevent 18-year-olds. Well, do they have a right to prevent 17-year-olds or 16-year-olds? These issues are very much in the forefront today. The New York case will probably give some guidance, but it won't give answers to the questions about 18 to 21-year-olds, about red flag laws, about background checks, about mental illness, about all of those things. The one fact we know is that the easy availability of guns in this country correlates with the fact that we have one of the highest rates of gun violence in this country. That doesn't mean we can cure that by changing the laws, but it suggests that if the states were to tighten up and the Supreme Court were to allow some tightening consistent with the Second Amendment, we might move slightly in the direction of reducing crimes, but there's no panacea here.
Yeah. I want to switch gears because a jury today found that campaign attorney for the Clinton campaign, Michael Sussmann, was not guilty of lying, which I thought was completely interesting because of the text message that makes it clear. He lays out, hey, I'm not part of the campaign. I don't have a client. I'm doing this for right. We know that wasn't true. But the thing I want to ask you about from a legal standpoint is this. If you can't get Sussmann, if you're Durham and you've gone after Sussmann, you can't get him, does this sort of send a message that, hey, you didn't get the little fish, so now you're not going to get the medium fish or the big fish?
No, I don't think it should send that message. It should send the message that if you're going after people for crimes that are political in nature, they better be serious crimes. And these crimes of lying to the FBI, most people don't agree with that. They don't even know that you can't lie to the FBI or a local policeman. The FBI lie all the time. That's part of their modus operandi. They tell you the evidence is stronger than it is. They tell you their co-defendant has testified against you. And a lot of people feel the only way you shouldn't lie is if you put your hand up and the other hand on the Bible and you swear to tell the truth. So I think this verdict says two things. Number one, if you're going to make a case against politicians, it better be a case that would be strong enough to survive, whether the person is a Democrat or a Republican, because there has to be the same rule for Republicans and for Democrats. And the second one is don't indict for these crimes that are not particularly sympathetic to juries, lying to the FBI. Those don't tend to get convictions. If you lie under oath at a deposition or at a trial, that's different. Although today, even people who lie on depositions don't get indicted. So I don't think this necessarily sends a message. Durham should continue to focus. He should go up the ladder. Even if he couldn't get the small fish, he should try to get the big fish if there is enough evidence of a serious crime. But I hope that the future crimes he goes after are serious crimes like conspiracy or obstruction of justice or bribery or tampering with evidence rather than lying to the FBI under these circumstances.
Okay. Interesting take. I know a lot of conservatives are pushing around a lot of information about the connections to the judge and all this, but we don't have time for that. It's always great to get your opinion, though. Thank you, Professor. I appreciate you being with us.
My pleasure, always. Thank you.